When a father gifts his property to his daughter and then takes it back and then sell the same property to his own son, can the daughter get it back? This actually happened in the case of N.P. Sasindran versus N.P. Punnamma. In the year 1985, father, through a registered settlement deed, gifted a property to his daughter with three conditions: that he will live in this property until he is alive, after he dies, his wife will live in the said property, and he can also avail a loan of amount not exceeding rupees 2000 by pledging this property until he is alive. But in the year 1993, he cancelled that deed and sold the same property to his own son. In the year 1994, the daughter went to the court, but in the year 1995, the father died, and this became a fight between a brother and a sister. The learned trial court held that this is not a gift, but it's more like a will of a father, and a will can be revoked anytime parent wish. And hence, in 2001, the learned trial court dismissed the whole suit. Daughter then filed an appeal before additional district court, and additional district court was of the same opinion and dismissed it. Daughter then went to Honorable High Court, and Honorable High Court was of the opinion that daughter will have the right to get the property back. Son was very furious, and therefore he approached Honorable Supreme Court of India. But in the year 2023, the daughter only passed away, and now the fight was between the legal heir of daughter and the brother. The Honorable Supreme Court held that the question that if the property will belong to daughter or not will depend upon the nature of the document which was executed by the father in the year 1985, whether this document was a settlement deed, a gift deed, or a will. The Honorable Supreme Court held that a will is a kind of document in which the testator decides the fate of the property after he dies, and the testator unilaterally can revoke the will. Now, coming to the settlement deed. In settlement deed, a person transfers his property to another person either immediately or after passing of certain events, like after he dies or certain other person enjoyed the said property, and these transactions are taken out of love. And in the case of settlement deed, it cannot be revoked unilaterally. In case of gift, Honorable Supreme Court held it's a gratuitous gift, a grant by the owner to another person, and it does not kick after the death of the person. The Honorable Supreme Court of India held that the 1985 document was executed out of love, as was seen through the language of the document. There was transfer of ownership, and there was an imposition of condition that I will stay in this property till I'm alive. After my death, my wife will stay in this property. Those were the conditions, and therefore it was a settlement deed. And Honorable Supreme Court also noted this condition that father said that he will be able to pledge the said property to avail loan not exceeding more than 2000 rupees. The court was of the opinion, why was there limit at the first place if he's the absolute owner? That means he's not absolute owner anymore, and hence the Honorable Supreme Court of India held that the property actually belongs to the daughter, and the daughter was the absolute owner of the said property.